When you boil it down to its core, a special needs trust is implemented and executed to ensure that the individual's public benefits, because the beneficiaries are usually disabled, that their benefits are not supplanted, they are supplemented. And so it's a way to increase the quality of life, to increase the care without invading or disqualifying them from public means-tested programs.
Hey y'all, this is Kosta, and today I'm here with my guest, Tyler Lannom, founder and attorney at Lannom Law. Tyler is a first lieutenant in the Army Reserve Judge Advocates General Corps and served as an assistant public defender before turning his focus to elder law, veteran disability rights, and civil litigation. Today we're talking about care planning, special needs trusts. So Tyler, generally speaking, what is a special needs trust and how do they work?
So special needs planning is a huge passion of ours here at Lannom Law. And special needs planning, special needs trust, what exactly is a special needs trust? Well, it's not a whole lot different from your routine living trust, except for some very specific differences, right? We have the grantor. I think it's good to go ahead and define the players here on who is involved in a trust. And then before I answer that, you have a grantor who is signing a trust agreement, a document that is making this legal entity, this relationship between the trust beneficiary, who is receiving the benefits from the trust, and the trustee, who is the custodian and who is responsible for administering the trust for the benefit of the beneficiary. So that's what a trust is, and there's many different types of flavors. Today we're talking about special needs trust. And what that is, when you boil it down to its core, a special needs trust is implemented and executed to ensure that the individual's public benefits, because the beneficiaries are usually disabled, that their benefits are not supplanted, they are supplemented. And so it's a way to increase the quality of life, to increase the care without invading or disqualifying them from public means-tested programs.
So let's say, for example, someone is born with a disability. Mm-hmm. And typically individuals that are born with a disability have some type of access to Medicaid benefits that will provide some type of services like personal care, things like that. How does a special needs trust supplement the benefits that they may receive from Medicaid? How does that process work?
Well, you're absolutely right, Kosta. Lots of individuals, lots of Americans are disabled from birth. It could be Down syndrome, cerebral palsy, a cognitive neurodegenerative disease that allows them to receive Medicaid essentially from birth. Could be a genetic heart defect, those types of things. And so they're receiving Medicaid benefits from birth. And as they reach 18 years of age and become a legal adult, they have other benefits that they are then privy to, such as supplemental security income, SSI, in addition to their Medicaid, their health care costs. And so what I mean by supplement is when these individuals traverse childhood and they enter into adulthood, we want to ensure, because these people are largely may not be able to enter the workforce with those types of disabilities that we've just outlined. And so what we want to do is ensure that they remain able to receive their health care benefits through Medicaid, that they're able to receive their supplemental security income to live. And so what this special needs trust is utilized for is to, if they were going to inherit, let's say, assets from mom or dad, let's talk about just accounts for a moment. Let's say there's $200,000 that was going to go to John, who's the disabled individual with cerebral palsy in this instance. We want to ensure that that money does not flow outright to John once he becomes an adult, because that would disqualify and certainly could have the risk of depriving him of those means-tested benefits, which are quite critical for his life, especially when his parents, age and would become older. And so this special needs trust, also known commonly now as a supplemental needs trust, is the recipient of that $200,000, $500,000, whatever the asset is that's going to be transferred to the trust. And that asset is then thereafter used for John, to supplement those benefits. What could it be used to supplement? A variety, I think we'll probably get to momentarily, but a variety of things, from medical cost to entertainment, vacation, and to rent.
Helping to pay for their mortgage maybe or something like that, or their rent, like you said.
Absolutely.
So can you set up a special needs trust for somebody over the age of 18? Like, let's just say, for example, somebody is perfectly healthy, right? And we're going to talk a little bit about the common scenarios, but I just want to I want to hammer down on this. So let's say that somebody turns 18 years old, okay? Mm-hmm. Let's just say they're 30, and they get into an accident of some kind, or they have some kind of catastrophic medical event. Can you set up a special needs trust after this event occurs?
Okay, and so your question is really two here. First question is, can you set up a special needs trust after an individual turns 18? Absolutely. Right. Okay, that can be done when the children are still minors, but very commonly at our firm, parents or guardians are coming to us with adult children, and then they're finally taking action, realizing we need to have an estate plan in place for our adult child. And so, the fact that they're an adult does not deprive a third party from setting up that trust for their benefit. Now, your second question is, what if they're an adult? They were not disabled, okay, but then they're 30 years old. They have an interstate wreck. They have a vehicular accident, and there's severe back injuries, paraplegia, something like that, and they are the recipient of a large personal injury settlement. Let's say $1 million, for instance. That's commonly what we come across working in conjunction with personal injury lawyers and other entities that interplay with special needs. And so that individual then, is looking at a lifetime of care. Okay, and so they're wanting to receive Medicaid eligibility. Likely, this individual may not be able to walk again, if he's paralyzed. And so he's then thereafter looking at supplemental security income, which is not based on work credits. And so there are two types of trust. I think this is good before we move on to the next section. I probably should have mentioned that at the outset. There is a third-party special needs trust, which is set up by a third party. Usually that could be a parent, it could be a friend, a sibling, for the beneficiary of the trust. The situation that we're talking about, the individual has been injured and they have money that is theirs. It's not a third party's. That, in this case, John, who was in this vehicular accident, is actually the recipient himself of this personal injury lawsuit. And so there is something called a self-settled trust, a first party special needs trust that's basically implemented under Section 1396 of the code. Without going too far into the weeds, it's what allows us to do this. And so the individual can set up this trust themselves, or their conservator, parent, or guardian can set it up. They just have to have the legal right to use those assets that are John's in this instance for himself. And so in the case that we just outlined with this car crash, this wreck, the individual could then thereafter set up this first party special needs trust. The money could go directly to this trust. It's also known as a Medicaid payback trust. But he then thereafter could immediately be eligible for public benefits. The only main difference is, for the listeners, those first-party trusts, they're also known as Medicaid payback trusts because one of the caveats is when those assets go to the trust, thereafter the beneficiary can immediately receive those public benefits. The residual beneficiary, when that initial beneficiary passes away, has to be Medicaid, typically. I'm licensed in Tennessee. That's certainly how our trusts are going to be regulated, and that's typically the way it's regulated federally across the United States. And so there is going to be a payback provision based on what Medicaid and those government benefits have paid out over the duration of that individual's life.
And so essentially what that means, just so that I can put it somewhat in layman's terms, is the beneficiary has full access to the trust and has access, as long as it's set up this way, and also has access to Medicaid benefits. Once the beneficiary passes away, whatever is spent on his care through Medicaid, the individual who inherits the trust, I guess you could say, or the money in the trust, has to pay back Medicaid before they can gain access to that money if anything's left.
You got it, Kosta. That's right. So this basically the state entity, Medicaid, is gonna receive their share first, and then the residual beneficiaries, let's say siblings in this instance, or his children, would then receive the remainder.
So not to get too technical, but why would everybody not just opt for a third-party trust then?
Well, so let's use this example again. I want to stay here. I think it'll be good for the listeners. So why would John in this instance basically have to use a self-settled first-party trust? Well, because he wasn't just, he didn't have this disability. This is not mom or dad's money. This is his money. And so
I see.
It's a first party. It's self-settled. And so even though a parent, a conservator, a guardian can also set up this first party D4A trust, it's whose money? It's the assets that were actually the beneficiaries. And so the government, through that legislation, allowed this played out over time through policy that congressional legislation had to occur that, okay, we need to allow these folks to also receive means tested benefits. But that's the reason. Okay. We can kind of go on further there, but third party trust, you do have some asset protection because there is not a Medicaid payback provision.
I see. So we're going to talk about common scenarios, and we may have covered a lot of them already in this discussion, so you're going to have to fill in the blanks after this last question. What if you are a child of someone that is disabled? So let's just say, for example, your mother or father who's 70 years old is disabled and requires care. Would you set up a special needs trust for that individual?
Well, that is a scenario, and we can stay there for a moment. Part of this is, our firm, myself and my law partner, we have a Master of Laws in elder law and estate planning, and special needs planning really is a subsection of elder law, right? The scenarios that we just spoke about were primarily we spoke about an individual who's disabled from birth. We talked about a young adult who was disabled in young adulthood. And now we're talking about the intersection of when a special needs trust would be used for the elderly. Now, in the situation that you've just outlined, Kosta, is would a child set up a special needs trust for their parent? For their parent, and they could. Certainly, if the child also is doing quite well and they have assets to actually fund that trust for their parent, they could certainly do that. Or they could simply just supplement their care from their personal assets. What is more common is a community spouse, okay? Let's say in this instance we have Susan and Alex, and Susan has had a severe stroke coupled with significant dementia. She's living in the state for quite some time. And John's worried that if he predeceases her, that their assets are going to deprive her of her current Medicaid benefits and that she may not have enough assets to live on. Oftentimes, a spouse can set up a special needs trust in their last will and testament that would allow this entity to be created if they predecease this institutional spouse. And so you've got these spousal assets, right, that are not going to have to be spent down and actually can be utilized to supplement their elderly spouse's benefits for the remainder of their life. We often see it with spouses, not as often from a lineal descendant. Yes.
And would there be a look-back period on those assets? A 5-year look-back period like Medicaid requires in most states?
I'm so glad you're asking this question because this is such a misconception really in the space. The internet's a wonderful thing. LegalZoom and those things are great as well. Sure. When it comes to elder law, you really have to have someone that works in these areas. So when we're setting up a trust agreement, and let's assume real property or other assets thereafter are moved to a trust, okay, and then Sarah or Susan goes and applies for Medicaid. There is look-back periods in all states, okay, and certainly in the state of Tennessee, there's a 60-month look-back period, and they will look at assets that were conveyed from the marital estate, from that institutional spouse's name. Where did they go? And if they go to a trust, it's no different. There's going to be a look back period that could create disqualification. What is often used in that instance is if Susan needs to achieve healthcare is always the most important thing. At our firm, we're always looking at asset protection. We're looking at protecting families, protecting wealth, protecting their loved ones. But the first 50-meter target is we want to achieve their healthcare and make sure that their quality of life is paramount. And so we need to make sure that that's being done. And there is very similar to the first party trust, Costa, that same legislation, 1396 of the U.S. Code that implemented that D4A first party trust. It allowed what's called a Miller trust, okay, a qualified income trust for folks that need public benefits now, okay, without disqualification. In that instance, we basically, let's assume Susan, she's got a brokerage account or she has, a significant pension coming in that is disqualifying her from receiving TennCare benefits here in Tennessee. Okay.
Sure.
Which is our state Medicaid program. Essentially you can move those assets, that excess income to a qualified income trust, which is essentially, it operates very similarly to a special needs trust. That would allow Susan to apply for and achieve her Medicaid immediately. Again, what's the caveat? There's going to be a Medicaid payback provision. Yep.
That payback provision gets you every time. So Are there any other common scenarios that we haven't discussed that you encounter as you're setting up these trusts?
Yeah, I could just briefly summarize them again. You are interviewing a lawyer, so I hope the listeners are able to follow. But it's important to know how it operates. But the common scenarios are, to recap, oftentimes either for minor children, more commonly, we see lots of parents that are coming to us for their own estate planning and then utilizing a special needs trust for their adult children who may not have it could be a serious disability like what we described earlier, Down syndrome, paraplegia, cerebral palsy, all of those things, a congenital heart defect. It could also be that maybe they are working, but they're significantly autistic. They're in public. They're in Section 8 housing. They may just not be. They're very irresponsible. As long as they meet the criteria from the Social Security Administration that they're disabled, okay, and if they're receiving some types of benefits from the government, we don't want to shut those off in the future. And so it's prudent to set up a trust for the benefit of that beneficiary. Other scenarios, though, what we just outlined, lots of married couples as they go through the aging process and they're aging in place. Oftentimes we may have a husband or wife come to us in tears that their spouse, their dementia is progressing. What can we do? We're looking at asset protection. We're looking at folks like yourself, Costa, that are in the long-term care space to help her care immediately. But then we're looking at the future. And oftentimes a special needs trust is prudent in the spouse's estate plan.
So there's a lot of different trusts out there, and I'm sure we can get into it, but we just don't have the time. But I would like to know, with regards to a special needs trust, what would you identify specifically as the unique benefits? Preservation of quality of life. That's really what it comes down to. There are wonderful innovators, again, in the long-term care planning space that are doing a great job of making sure that our society is fair and equitable. What special needs trusts allow is the deterioration and erosion of wealth and assets. It allows those assets to be kept to supplement, again, those government benefits. And as we become an aging population, those are being used more and more often. So from a policy perspective, it makes sense to have extra assets to assist those benefits. And it's also helpful for the family. So that's really the unique benefits of them. Absolutely. So who qualifies for a special needs trust? And this question, I think, will be very interesting. I'm curious to hear what you have to say. Do you need a lawyer to set up this type of trust?
Well, I'll take the second question first. Do you need a lawyer? And I'm just going to say, yes, you do. And here's why. I believe, we are going into just an unprecedented age of technological advancement and software and the internet age and the free flow of information, and it's amazing. And there are going to be some type of commodities in law, that are going to be more accessible to the general public. This is not one of them, as the listeners have probably picked up on just in our conversation. Why do you actually need a lawyer, though, to execute? Now, Can you go on to trustyourwills.com, LegalZoom, some other type of software, or find a trust agreement somewhere, a piece of paper, a document to sign? Yes, you can. The problem is you are really, when you retain an elder lawyer or an estate planner to execute and draft your special needs trust, number one, they need to be proficient and understand the intricacies of Medicaid, primarily, of supplementals.
And it's so complicated.
I'm continuing to learn every day as a practitioner. Okay,
I know.
It's a lot, and it changes. It changes. So I would just say they need to ensure that they're looking at NALA, the National Academy of Elder Law Attorneys. Does your attorney do this commonly? Do your research, do your due diligence, and make sure that you're using a planner that understands these things. The second thing is they understand other players in the space. Who are the healthcare agencies that are reputable? Who are the CPAs that do tax returns for trust? They're going to have a network of people to help your loved ones and leverage that. Okay. So, yes, you do need a lawyer to do this. But
can I ask
go ahead.
real quick before you go on, what happens, and I'd like for you to speak to the people that watch this show that don't live in Tennessee. Let's just say, for example, they watch this episode and they reach out to your firm, but they live in Michigan or Colorado. What would happen during that transaction? I mean, would you be able to point them into the direction of someone in their state that focuses on elder law? And you said that they need to be proficient. And we've talked to a lot of attorneys that specialize in elder law, a lot of financial advisors that specialize in estate planning. What is proficient? What does proficiency mean to you?
Well, that's a good question, Kosta. And does it mean that they have to have an alphabet soup by their name? Not necessarily at all. But go on their website, okay? I would say certainly, first off, if they reach out to our firm, we're in a network, okay? We can reach out to our colleagues in NALA, Wealth Counsel, and other groups that we're in to assist them in finding someone that we believe is proficient. But what that really means is that this is a practice area that they focus on, okay? It's very, very different than what the lion's share of attorneys do. This is not litigation. This is not what most lawyers do day to day. And so they need to make sure they have someone basically that does this routinely in their practice. That's what proficient is. Someone who's in this space, who's consistently learning and is practicing routinely. And that is one of the things that at these annual and biannual seminars that comes up, there's lots of lawyers that are starting to dabble in trusts and estates, and it can be very, very costly for them. There is lots of liability here, and so they need to understand that.
You would be astounded how many people tell me that there is a alternative to the 5-year look-back period look-back period in general. Some are small, some are less. There's 3 years, there's 2 years. But astounded, as we're having these conversations, how many people say that are attorneys, that are in estate planning, that say, well, no, there is a vehicle that you can use to actually get outside of this look-back period and receive services immediately. And up until this point, and I'm sure a lot of people that watch the show, I had no idea that was a thing. So proficiency, like you were saying, I think you have to almost be a steward of your profession and constantly be learning and going to those conferences like you're describing. 3 questions. Number one, if you could give me a range of how much a special needs trust would cost to set up. I'd like to know how a special needs trust is typically funded. And then lastly, I want to know how the funds can be spent.
First question on pricing. That's a good question. And it varies pretty largely because some firms are strictly that service oriented. They're going to walk them through that drafting, through the signing of the trust and hand it over and the funding and everything else is going to fall onto that client, which is fine. That's just how some firms do it. And they need to go out and then handle the rest of kind of putting the rest of the plan together. And then other firms will assist them with achieving their public benefits, doing the Medicaid application, helping them achieve Social Security, doing the appeal process, being there for them quarterly and helping them through the care process, and kind of being that intermediary between the firm, the client, and these other agencies, be that the state, be that a nursing home or a community-based healthcare organization. And so the range could be anywhere from $2,500 to $10,000. And some firms will kind of give a sliding scale approach on how much involvement do you want your counselor to be, your advocate to be, and allow them to make that financial investment on what they would like to do.
So let me ask you, is a special needs trust a revocable trust? But more importantly, what does that even mean?
Well, that's a very good question. I think I should define what a revocable trust is. Many people,
Please.
That's what they know. They read that online. They know people at church or at work that have a revocable trust, or mom and dad have a living trust. Okay, those are synonymous. A revocable living trust. Okay, now the players don't change, right? Anytime we have a trust agreement, we've got a grantor who's making the trust. Sometimes they're the same person as the trustee that's the custodian of the trust assets, and then you have trust beneficiaries. A revocable trust, it usually, the grantors and the trustee are the same. It's revocable, meaning the client can amend the trust, they can revoke it, they can add to it, they can change the trust terms, they can change trust beneficiaries, they can amend it. And so that's why it is revocable. Now, it also is very different from a tax perspective, During the grantor's lifetimes, it is usually going to be taxed through their Social Security number, And so there's not going to be a separate tax ID number, a separate tax return. Now, special needs trust, what is it? It is an irrevocable trust, as we say here in the South, So it's very different from a revocable trust, And so when the trust agreement is executed, this conceptual bucket, for the listeners, you're going to put the lid on it, and it becomes irrevocable upon the execution of that agreement, largely, Third-party trust, they can keep certain powers like changing trustees and those things. But why does it have to be irrevocable? Because the trust beneficiary, they are not the trustee. They are not the grantor, And the trust, is outside of their taxable estate, They are not their assets. They do not have control over those assets. And again, those assets are used to supplement their public benefits. And so this special needs trust has a separate tax ID number, and a tax return will go up annually. It's taxed as a pass-through entity. Earnings that are distributed out to beneficiaries are deducted from those earnings. And that's kind of, in a nutshell, how the taxable side works. I'm certainly not a CPA, but that's, in general, how trusts are taxed. They have their own tax brackets. But that's why it's irrevocable. That's why in this case.
I see. And so once you take that money out of the trust and you pass it along to a beneficiary, does the beneficiary have to pay taxes on that money?
I'm really glad you just asked that, because what I need to make very clear to the listeners is that's one of the most important things to understand for the trustees. And many people choose a family member, which is fine, or a layperson to be that successor trustee for this special needs trust. And that comes with many pitfalls, as opposed to a revocable trust, which is much easier to administer. They have to be proficient on the healthcare needs of the beneficiary, their public benefits, making sure that they're staying in line with the Social Security Administration and other federal guidelines. Distributions can never be made directly to a trust beneficiary, a special needs trust beneficiary. Why is that? Supplemental security income, SSI, and Social Security, they will see that. They will deduct their income, their monthly income. It could, depending on what the distribution is, it could just disqualify them for a period of time. And so I think I should define, what are those distributions used for?
Please do.
If there is real estate that has been moved to the trust, and that's a whole separate question, like say a home for the special needs trust beneficiary, maybe that they are paying the mortgage note, or they're paying their rent if they're in an apartment or condo, that would be.
Would it be used for, let's just say, for example, they receive services through an agency a few hours a day? And when that agency sends an invoice, they invoice the trust, or let's just say they invoice the client, and the trust pays that bill. Would that be a scenario?
Absolutely. And that's actually probably the most important benefit that's going to be paid for by the trust is supplementing their healthcare costs. If they've got, go ahead, Kosta.
Oh, no. I was going to ask you about medical bills, but typically if this person is enrolled in Medicaid, they wouldn't have any medical out-of-pocket medical bills. But I guess technically if they wanted to opt for like a higher quality medication that's not covered by Medicaid, they would be able to use the funds inside the trust to pay for that medication, correct?
It's absolutely that. There are medications that fall outside the scope sometimes of what Medicaid or Medicare will pay for. Oftentimes they're using those trust assets to pay for an extra sitter, at the nursing home or their community-based healthcare home, just extra care, extra entertainment there. Also, memory care that may not be paid for through Medicaid, physical therapy that may not be covered once Medicaid is received. There's a host of benefits that can increase that beneficiary's quality of life that those trust assets otherwise, would have to been basically spent before the individual would have been able to achieve those benefits.
Mm-hmm. Are there any situations where a special needs trust becomes a disadvantage to an individual or their family?
Well, that's an interesting scenario. I would start off by saying there shouldn't be. If the practitioner has been thoughtful and they've analyzed, the client, who their client is, and whether that trust is going to be a prudent decision, it's always going to be useful. Are there scenarios on when it can be a disadvantage? Well, if the lawyer or the family and the client don't do a good job in determining who's going to be that successor trustee, there could be misuse of funds, incompetence, fraud. I mean, those types of things. Choosing a trustee, regardless of an estate plan, is one of the most important decisions that the client and attorney need to make. And so that could be a disadvantage. If there's not going to be a significant amount of money funded to the trust, if we're talking about money maybe less than $100,000, an ABLE account can be used, or maybe they use that asset instead of going through an estate plan and the cost, the admitted cost and the administration of administering a trust, just the time and energy and work involved there. Maybe that money could be spent on something else for that beneficiary. And so if one is being used prudently, it should always benefit. There's not a lot of downside, but sometimes they're set up when they shouldn't have been, if that answers your question.
Yeah, so human behavior is essentially
You got it.
What is at fault? Before we wrap up, I want to ask, so you said a special needs trust has their own tax ID number, and it's used as pass-through income to help pay bills, like the mortgage, services, things like that for the beneficiary. Are you taxed on the money that's in a trust? And if you are, is it taxed as income? Is it taxed as capital gains? Expand on that.
Yeah, and so first off, that's why it's really important to us as estate planners. We always have a network that we lean on, and it's important for us, right? Sure. Because we understand the tax code and how it operates. But it's those things right there that we need to make sure on when the tax return goes up, that's done correctly to make sure that those taxable events are low. But yes, when distributions come out of the trust, those are taxed as income. Those are not going to go on the trust tax return. When it comes to capital gains and how a trust is going to pay capital gains tax, that's where good accounting comes in. That's what I'll say on that.
Sounds good.
Yeah.
I like that.
There can be, though. Absolutely.
Okay. So we always like to end the show with a call to action. What's your best advice for someone entering the long-term care industry as a patient, a caregiver, or an industry professional?
That's a great question. This is an industry, and right today you're interviewing someone from the legal space, which we all enter the long-term care space from different vantage points. And so I will speak just to the clientele and the demographic that we reach. And folks, if there's someone in your family that you believe is going to need long-term care services, so I guess I'm going to speak from the patient out point. Do not put off the estate plan. Okay, your lawyer is a critical piece to the puzzle. They have relationships that are going to intersect on every area, from achieving your loved one's benefits to protecting assets and to leading you in the right direction and to making that point of contact with your healthcare provider. And so we say this every week, Costa, but my main advice is for patients and their families is do not delay. Don't be scared of it. It's actually a really powerful thing that you're doing, taking control of your long-term care. So take action.
Absolutely. And so from an industry professional standpoint, do you have any advice for other legal experts that are specializing in elder law?
Well, I would say on attorneys that are coming up into the space, there's a great need, and it's a wonderfully rewarding area. The incline is very steep, and that's not a bad thing, but people need to understand that we're really dealing with very, very serious moments in people's lives that sometimes can get quite complex. And so the learning curve is higher than other areas, but it's wonderfully rewarding, and young attorneys should be entering the space, but just be prepared to get heavily involved.